Yes, it's another news time on this Victory Voice TV where you get all those news that matter to us. This one is breaking news. Everybody should come and hear. In fact, I'm not the one that will give you the analysis, but I have to introduce you to it. Mazi is challenging the erroneous ruling of Supreme Court. Yes, challenging Supreme Court ruling. Remember when we left this Supreme Court ruling? Mazi is going back to that because there's something that I need to point out there where this error is coming from. Alright? People are tired of Mazi Nnamdi Kanu. But by the time he finishes with the Zoological Republic, like he said, Nigeria ga-adị Ghana. Ọ ga-eme ha vum n'anya. Because ha amadị onye ha na-akpa nkụ n'isi ụrụ ya. Mazi Nnamdi Kanu is serious and is ready to drag Nigeria to any length. This time around, it's no longer Nigeria dragging Mazi Nnamdi Kanu because nke ahụ agaala. He has found out that they don't have basis. What they are just doing is buying time. So now, I want to get the details of what is going on, why he chose to query and drag this case back to Supreme Court. Now,
in the case of Kanu, frankly speaking, the charges can hardly be proved. One of the counts is sedition. Sedition was pronounced illegal and unconstitutional in 1983 in the case of Otto Nwankwo and the state. So I don't know, I can't see how some of those charges will stand in law. So the choice before the government is to have this matter resolved politically.
Nnamdi Kanu is going back to Supreme Court because not that Supreme Court found him guilty, but Supreme Court, after condemning the atrocities of the federal government, after saying Nnamdi Kanu did not jump in and so on and so forth, that Supreme Court relied on a law that is not existing again to send Nnamdi Kanu back to Federal High Court for prosecution, like let him go back there, let them start the case from Federal High Court again. That Nnamdi Kanu went back to the Supreme Court because Supreme Court cannot rely on a law that does not exist in the Constitution in a written law. So he explained a lot of things for me. So before I tune in my camera, I said, okay, let me speak what I know about this. And I'm going to speak more, not on the law aspects, or not on the law context, but on the intention behind the erroneous laws. All these things you are saying, it is the intention and interest of the people. And that is why both the UN report and so many international communities report, the judiciary and the Nigerian police force are the most corrupt institution in Nigeria. How can you rely on erroneous law to detain somebody because Muhammadu Buhari's administration was the one that was holding Nnamdi Kanu, so they can manipulate the judiciary. They can ask them to do whatever they want to do. By the way, Kudirat Kekere, was she's a judge that was banned not to enter US, and she was one of the key, actors, one of the key actors, one of the judges that asked Nnamdi Kanu to go back to the High Court after condemning the federal government of the atrocities they level against him. And who is she today? I think she is the chief judge. So we live in a country where there is no rule of law, but interest is prevailing against the rule of law. That is the reality on ground. And that is why someone like Showore has been raising an alarm, because he himself is always in the court. According to him, when I see a useless court case, I will know that Nnamdi Kanu case is just a useless court case because the intention of the federal government is not because this man is guilty. By the way, if Nnamdi Kanu is guilty, they can't be telling him, drop Biafra agitation, let us leave you. If they claim that the reason why they are holding Nnamdi Kanu is because of what he committed, why then telling him to drop Biafra agitation so that you will leave him? Logic. We have to think. If actually they are determined to pursue justice, then why telling the same man, drop Biafra agitation, let us leave you? It is an evidence to tell you that the reason why they are holding him is not because he committed anything, but because of Biafra agitation. All right, that is just the introduction of this. Now, you can see this report from Sarah Reporters that reads that Nnamdi Kanu heads back to Supreme Court to challenge 2023 erroneous ruling. And this is the details. it reads that the detained leader of the indigenous people of Biafra IPOB, Mazi Nnamdi Kanu, has returned to the Supreme Court of Nigeria, seeking to challenge the per-inquiry judgment that shook the foundation of justice and destroyed the rule of law. I like this statement, that shook the foundation of justice and destroyed the rule of law. Now, let's go to the second paragraph. It says that in a statement issued on Monday by his legal team and signed by Barrister Njokon Jude Njokon, entitled A Judgment That Destroyed Justice, Kanu's lawyer stated that the Supreme Court ruling of 15 December 2023, which overturned the Court of Appeals decision discharging Nnamdi Kanu, was not merely an error, but a conscious judicial maneuver designed to keep him in a perpetual captivity. According to the statement, the 5-member panel, led by Justice Garba Lawal with Justices Emmanuel Ajem, Kudirat Kekere Eko, Tijani Abubakar, and Ibrahim Musa Saundawa, concurrent, knowingly rely on a repealed law to remand Kanu for trial. So, you see, this is the major context that my lawyer friend told me. He is a criminal lawyer, so he understands the trial of Nnamdi Kanu very well. That a court, a competent court, you know the reason why I continue to ask this? If actually what these lawyers are saying, what Nnamdi Kanu is saying, is totally correct, as I said before, I'm not a lawyer, that this court of law are relying on a repealed law, a law that does not exist in the Constitution, in a written law again, to judge this man. It will never be good at the end, though. It will never be good at the end if these people are actually relying on non-existing law. So it will expose the whole intention of holding this man. Because this is unacceptable. It is unacceptable to rely on a law that does not exist. That is to say that you can just wake up and say, you on this light. Why did you on the light? We'll sentence you to prison because you on light. And there is no law that states such a thing. You know, Falana was the first person that made this statement. Femi Falana made this statement before. When he made the statement, a lot of people did not understand what he meant. People started criticizing him. He said it was very difficult for you to jail Nnamdi Kanu because the law you are using to charge it does not exist. Falana made this statement. Now, let's continue with the article. It says, at the center of the controversy in the Terrorism Prevention Amended Act of 2013, which was repealed and replaced by Terrorism Prevention and Prohibition Act 2022, on 12 May 2022, more than a year before the Apex Court's judgment, the Supreme Court knew the law had died, acknowledged that a repealed status cannot sustain a criminal charge, yet proceed to resurrect a dead law to send Nnamdi Kanu back to the Federal High Court in Jogo alleged. I'm not a lawyer, okay? But if this is just exactly what it means that Nigeria cannot get well again. If these lawyers, judges, can see through a dead law and use it to charge someone, use it to judge someone, use it to be sustaining a judgment for someone to remain in detention, it is not going to end well. All right. He described the ruling as not an accident nor an intellectual slip, but a deliberate judicial ambush that misrepresented a dead law as a life. The statement argued that because the law under which Kanu was charged no longer existed, the Apex Court's decision was a jurisdictional nullity. A repealed law is a legal corpse. It cannot be revived, acted upon, or used to create criminal liability once the enabling status is abolished. The proceeding built upon it collapsed, Njogon stated. He added that by applying two contradictory legal positions in the same ruling, first admitting that a repealed law cannot sustain a charge, and then remitting Kanu for trial under the same law, the court lost jurisdiction. No crime of finality can shed a nullity. Where a judgment is rooted in illegality, the Supreme Court has inherent power and duty to purge its own record, he wrote. The legal team further accused the Supreme Court of breaching Section 122 of the Evidence Act of 2011, which obliged court to take judicial notice of all repeal or newly enacted laws. And this is what he said, in quote, by pretending that the repeal 2013 Act was still in force, the court acted per inquirium in ignorance of a binding statutory duty, Njogun contended. He insisted that a per inquirium judgment is not protected by the doctrine of finality, arguing that the apex court has in the past set aside its own decision made in similar circumstances. Beyond the legal technicalities, Njogu said 2023 judgment effectively crushed Kanu's constitutional protection against double jeopardy under Section 36(9) of the 1999 Constitution, which bars a person from being tried again after discharge or acquittal. The Court of Appeal had discharged Nnamdi Kanu, which triggered this constitutional shield, yet the Supreme Court stripped him of this right and sent him back to face the same charges the statement raised. So the article continues on and on. But let me stop it here.
You can all see why they are forcing him. And thank God, Nnamdi Kanu is a nation, not like a nation. Because an individual cannot face nations and win them in this form. It's a face down on Nigeria. Face down, total face down. Shame upon shame. Under which law are you trying me? They have to answer Nnamdi Kanu. And that is why they are forcing him to open a case. A case under which law? You see, Nigeria, you are gone. Una la la. You are messed up eternally. And that is it. Thank you everyone for following up this channel. God bless you all.